Good evening, people. This is Clarissa Williams today, coming at you. Every time I start these videos, I'm going to start off by saying make sure you watch my YouTube channel. It's Clarissa Speaks the Truth, because that's what I do. And you're going to find a lot of other interesting videos out there proving that Greenville County Department of Social Services in the state of South Carolina has falsified court documents, forged them, notarized some of these documents, abused their powers, kidnapped my daughter from school on December the 14th, 2021, placed her in foster care, committed malice against me, perjury. What else did they do? Oh my God, they've done so many things. And they responsible for placing my daughter illegally in the state of Georgia with her father, who was a two-time convicted felon, who has actually done prison time, probably about 10 years or more in prison, was on probation when they placed her, and who had a probation violation when they placed her in the state of Georgia illegally with this man by herself. And Judge Catherine Tiffany was the one that signed the order. Just stole her life from her, just took everything she knew from her family and friends, and placed her in the state of Georgia by herself with her father in the state of Georgia with no counseling, no nothing, no insurance. She didn't have anything. They just stole her life from her, embarrassed her in school, humiliated her. She fell into a deep depression. She told me she had contemplated suicide before. I mean, just a lot of stuff that they've done. My daughter don't know nothing about nobody but me and her family. Why would you take a little 13-year-old girl from her family and place her with a father, and you didn't even do a background check, and leave her in the state of Georgia all by her little lonesome self? And then I didn't even have visitation. Check this out. They gave me supervised visitation. He wouldn't even comply with visitation. I suppose got video calls. And I told him about this man character. This man don't follow the law. He got 2 felony convictions and a probation violation. You think he care about the law? No. He wouldn't even give me my 2 video calls, and I didn't see my baby for 8 months. 8 months, and I was crying. Almost had a nervous breakdown because, and I had to be careful what I said because she lived with that man, and she had to go down there with nobody to defend her. So I was scared to say anything because I didn't want him to hurt her or harm her. I don't know what all happened in that house, and that's one reason why they're trying to keep her away from me. But and those judges at Greenville County Court, they've been trying to cover up for them, and they for DSS, and DSS runs that courthouse. All kind of illegal falsified documents flying all over that courthouse and Department of Social Services. Yes, they are. Hearings ain't on the hearings not being recorded. Ain't no transcripts found. These people have gone to great lengths to try to silence me and to try to shut my case so I won't have any recourse, but it didn't work. God got me, so it's not gonna work. So I'm gonna kind of really just pound down, hammer away at Department of Social Services, Sam Weldon and Haley Rogers. Man, that's what I'm finna pound away at today. So I'm gonna call it Dissect the Document Day. So I'm probably have 2 parts to this video because it's really long. So we know that all of that ex parte petition. Okay, let me tell you the most important thing. I shouldn't even be having a case. DSS shouldn't be having my baby. The state of South Carolina has a law 63-7-920 states that you get 45 days. DSS get 45 days to do an investigation, interview witnesses, gather facts, and 45 days they got to say I'm pretty much guilty or innocent. The only way they can go over 45 days is they get an extension, which they didn't have. And I verified that, and I know they didn't. Because if they had an extension, they wouldn't have lied and changed the date saying they received the report on December the 3rd. They should have just stuck with the original day because they received it on October 27th. Here's the first proof. This is this man, Dr. John Melville, don't know us, me and my daughter. He put, can't see it good, that says encounter date 10/27/21. He never had no encounter with my daughter. I don't know that man. That man illegally went in my daughter's medical records and started going through her records and built the case. And then said, I've never spoken to the medical professionals whose notes I have read. This opinion is based exclusively on the information received and could change if additional information were received. Did you hear that? They took my baby based on this man's opinion who don't know nothing about us. He said progress note sign. You don't got no progress. You don't know nothing about her progress. Dr. John Melville up in Charleston somewhere. We live in Greenville. I don't know that man. So that's how this case came about. This little man filed this false abuse and neglect report against me. Him and DSS collaborated this. So that's how this case came about. So on December the 14th, Sam Weldon went back up in there because, you know, he filed a petition against me asking family court judge Teresa Dunbar to take her, put her in their custody. She did. She signed it. They went in their custody. Then I had to be in court the next day. And that ex parte order, it told me from Judge Teresa Dunbar, they told me, let me show you now. I'm showing you. I had to be in court the next day. At 2 p.m. They took her December the 14th. I didn't have 24 hours to prepare. I didn't know where I was going. I had no idea where I was going to sit in that courtroom. Now, I told y'all, this ex parte order is a generic document that they're using over there at DSS. All they do is change the defendant's name and the child's name. Because I'm going to read this to you real quick. I don't have time, but I'm going to do it. The matter came before me on December the 13th, 2021 on a petition for an ex parte order. Plaintiff requests that this court, acting pursuant to the authority given it under South Carolina Section Code 63-7-740, issue as ex parte, granting emergency protective custody of the minor child. That's her name. Plaintiff also alleges that probable cause alleges to believe that by reason of abuse or neglect there exists imminent and substantial danger to the child's life, health, or physical safety. Plaintiff has submitted a sworn affidavit in support of the allegations, and I have studied the information contained in the affidavit. The affidavit and its allegations are incorporated in this order. Based upon the foregoing, I find there exists probable cause to believe that by reason of abuse and neglect there is imminent and substantial danger to the life, health, or physical safety of the child. I find that DSS is a proper party to have emergency protective custody under such circumstances. I also find that based on this affidavit, DSS exercised reasonable efforts to prevent removal. We know that's a lie because I already pulled this out with DSS. Reasonable efforts didn't even put no efforts they made. They said they didn't know me. No services have been offered for the involvement of this family. DSS did not have prior knowledge of this family prior to the removal of the minor child. DSS was unable to provide services to prevent the necessity of the minor child. They said they didn't give me service, and they said they didn't know me. So I don't know why a judge, all three of them said that. Judge Conant, she said it twice. Judge Teresa Dunbar and Catherine Tiffany said DSS made reasonable efforts. Where did they make reasonable efforts at? Because this is a sworn affidavit. Where they reasonable efforts at? And then this wasn't signed until December the 14th, remember? Judge Teresa Dunbar said this matter came before her on December 13th. She examined it. We already went through that, so I'm going to stay away from that. But this is what Sam Weldon filed against me on December the 14th. There you go. Okay. And it is frivolous. Because let me tell you something. This case should have been stopped on December 11th. That's their cutoff date. After December 11th, they ain't have no evidence of nothing saying that I hurt or harmed my child. All they had was a termination fact sheet. That's it. Saying I took my baby to these doctors that she was referred to. That's it. And all they did was took this man, took all this, typed it up, and put it on there. And knowing that this man said this opinion is based exclusively on information. You gotta have facts when you take people's children. Facts and evidence, and you gotta work, and you gotta follow the law. They didn't do that. So, okay, the first problem I have with this document right here. I don't know who created this document. They wasn't a smart attorney. It says abuse and neglect. That should say abuse, and it should be a box for neglect. If I commit neglect, why you gonna check the abuse for the box for abuse and neglect? Why? No, you should check whatever you accuse me of. It should be no and. Y'all need to change that, honey. And see, that could be why they tried to charge me with physical abuse and medical neglect. Physical abuse is coming from, they saying I took my baby to the doctor too many times. Then they turn around and say medical neglect. Medical neglect is saying you ain't getting the child medical care. So that don't even make sense. Anybody with common sense would say, that don't even make sense. They just be throwing stuff because they know them judges ain't going to check nothing. So this is frivolous because you know you shouldn't have filed it beyond December 11th, Sam Weldon. And you know you did. And I'm just going to show this real quick. Let me show the ex parte petition. So you can see he filed this December 13th. Wasn't supposed to file it beyond December 11th, and he knows that. Okay, so let's get to roll. Dissect the document. So here we go. Summons, notice of hearing, right to counsel. Okay, now I was supposed to be in served this because this tells in here, it tells all the stuff they're alleging that I did and what I didn't do. This is very important. This is telling I got a hearing. Now I'm show you, prove to you that they did not serve me this. Defendants Clarissa Williams was served with the pleadings in court by the deputy. They met after court. They hand delivered this to me after that hearing. And here's the hearing, so you can see. And here's the judge. This judge is something else right here. I got more evidence on her than any other judge. Rochelle Collins, right there. December 15th. I didn't get served with this document. That's denying me my right to due process. Because I had no idea why I was going up in that courtroom. Only thing I had was what I read to you. It never told me what I did. I didn't have time to prepare. I had no idea because I knew I hadn't heard of harm my child. So I'm like, what is going on? I almost had a nervous breakdown, a stroke, and a heart attack all at once. So let's go. Here we go. It says, to believe that a case has arisen which invokes the jurisdiction of the court pursuant to Section Code 63-7-1660 is what this is about. As amended, will show the court as follows. And that means removal with services. Now, they got to give you services before they take your child, which they didn't do with me. That's another law they broke. Because you read the affidavit said ain't no services were offered. So let's read 1660 real quick. So they just said 1660. Let me tell you what, it's only two. Services with removal. Services without removal. So you gotta give the parent services. You gotta give the family services. Try to work with them. They did. They just kidnapped my baby because they didn't do an investigation. And they realized Haley didn't do the investigation. So I guess they tried to help her out based on belief and information. And thinking that running over to that family courthouse, they would get the documents signed, take my baby, try to make me take that treatment plan. They was going to be good. No, you ain't good. No, you ain't good. So we're going to start. We're going to keep that open. We're going to keep rolling. Okay, so now it says the child, 18 years old and under. That's where we resided. The father lives in Atlanta, Georgia. He lived in Decula, Georgia. And abuse and neglect, defined by 63-7-720. It says to hurt or harm a child. Taking a sick child to the doctor is not hurt or harming a child. Those doctors referred me to those specialists. It's in the transcripts, read it. And she was referred to all those doctors. And some of those specialists referred us to the doctors. Now, listen. A doctor is a mandated reporter, so is an attorney, so is a judge. They have to report abuse or neglect. Not one of her physicians contacted DSS or reported that I was abusing or neglecting her because they didn't know why she was sick. She had blood in her stool, she was vomiting, she was nauseous, she had severe abdominal pain, she had insomnia, she had nosebleeds, she had fever, something was biting our skin. She had all these lesions on her. She had this big old nodule over by her heart. She had inflammation. Her hair was coming out. She was having issues with her mouth. And I'm supposed to let my baby sit around the house like that. And I got the same symptoms. So you would have thought educated, halfway intelligent doctor would have said, well, if they had the same color skin that we have, they probably would have. They talking condescending to me, talking in a derogatory tone, really not wanting to hear me. And this baby up here telling the doctors that she's sick. And I'm taking her all around to these doctors. Like, I don't have time. I was sick myself, trying to take care of both of us. And if you look at our medical records, we had the same specialist. They didn't want to help us. They didn't want to. I bet if our skin color was different, they would have helped us a little more. So that's how we got to that little point. So she was sick. So I guess I was supposed to let her hemorrhage and die. So back to this little man right here. So it says, as stated by DSS worker. That's Haley Rogers. And let me show you this real quick. This is a sworn statement. Now look, personally appeared before me the affiant, who, being duly sworn, disposes and says that he or she is the plaintiff's agent in the foregoing action and that he or she has read the within complaint and upon information and belief knows the content of said complaint to be true. Haley, you signed this. Signed on December 14th. Sworn affidavit. Okay, so let's read this. Clarissa. Now, this is what, because Sam Weldon signed it. I don't see Haley's signature on this. But she swore that everything in here was true. Now it says, Clarissa has also refused to use the child's flow vent on a regular basis, despite the advice of multiple physicians. Okay? I refused. Okay. Let's see about that. So here's Dr. John Melville. This is the man we don't know who started this little witch hunt. Progress notes, date 10/27. He said in the counter, you ain't have no encounter with my baby. We don't know you and she ain't. And then he said, I have not interviewed this patient. She ain't your patient. She is not your patient. You is not her doctor. I don't know where you came from, where they pulled you out of. Okay. Now, Dr. John Melville said, mother has not used the patient's flow vent on a regular schedule, despite the advice of multiple physicians. Did you hear that? The mother has not used the flow vent. Okay. Well, Sam Melville said, mother has also refused to use the flow vent. That is a strong word. Saying I refuse to give my baby medication she needs. That's an inhaler to save her. She have an asthma attack. See, you falsified another document. Then they say Dr. John Melville at MUSC has deemed this case as strongly concerning for physical abuse and medical neglect. This case, that means they was already investigating me, as it specifically states on this document. So they already had a case. This man guy, I don't know how they got him. This case is strong. The only case him and DSS have will be an abuse and neglect case. 10/27, he said that. Then 10/27, he had said he had an encounter with her. So, okay. So it says it is there for the recommendation of SCDSS. No. Let me see. Seeking health care are inappropriate. I'm seeking health care for my baby. It's inappropriate. Clarissa has been non-compliant with doctor's recommendation. Clarissa has been non-compliant with DSS. The father stays in Atlanta. No, he stayed in Decula and has not been able to take responsibility for the safety and well-being of the minor child. That is strong. So why would DSS and family court judge place her with a man like this? And I told Judge Catherine Tiffany he got felonies. Why would you place him? This tells me this man is irresponsible. We're going to have trouble if we place this baby with him. They didn't care about the little black child. Look at that. That's serious. A judge placing a child to be neglected and possibly abused by a person she places in with. And then Judge Connors put a nail in the coffin and permanently placed her with him. After her guardian ad litem gave oral testimony and gave their written recommendations telling them not to place this child with this man. Take her away. Judge Connors didn't do it. You know it's illegal for a mandated reporter to do that if you know a child being neglected. And then DSS attorney did the same thing, recommended she stay with him. So let's keep rolling. Due to Clarissa not complying with DSS and refusing to name a potential caregiver for the child, DSS has concerns for the safety and well-being of the minor child. Ain't that something? Remaining in the care and custody of Clarissa Williams. It is therefore the recommendations of DSS that the child be placed in the legal physical custody of DSS. Due to Clarissa not complying with DSS and refusing to name a potential caregiver. Okay, I refuse, huh? Now, this is a case dictation note came from DSS notes. 12.1, investigations. Then it says 12.12, dictation. I guess it's when they put in the computer update. The mother does not have any family or friends the child can stay with. This is after I met with her on November the 3rd. A whole month and 9 days later, she said I didn't have no family, friends, or child to stay with. The mother has refused to sign any releases of information. I signed a medical release and a school release form on November the 3rd. I ain't got nothing to hide. It's transparency with me. Transparency. Now, she lied. The mother does not have any family or friends. Haley said that. She swore this was true. And Sam Weldon signed it. Now they come back and said, I refuse to name a potential caregiver. And then I'm come back right here and hit him upside the head. Really? Really? Because now they come back and say, DSS did not have prior knowledge of this family prior to removal of the minor child. No service had been offered, and says DSS had no knowledge of this family prior to the removal of the minor child. So on December the 14th, when you signed this, you said you had no knowledge of me. So how could I have refused to give you information? And how did you know I didn't have any family friends here? I was born here, so were my parents. So that's a lie from the pits of hell. That's about 3 lies I caught y'all in. Three falsified statements. 3. Right there, just in that little sentence. Let's keep rolling. That the above children were taken in emergency on protective custody pursuant to section 63-7-740 of the South Carolina Code. Or, ain't no or, which one was it? You know how you took this child. It was either emergency ex parte or was through law enforcement. Which one? You got to say which one it is. See, that's a deceptive tactic. Say how you took her. At the time of the protective custody being taken, there was a probable cause to believe the children's life, health, or physical safety would be in substantial imminent danger if the children were not taken into emergency protective custody. Based on what? Based on what? This little man say opinion. See, if you had went and talked to her doctors and our family, you would have found what you was looking for, because they would have said yes, she been sick. The opinion is based exclusively on the information received and could change if additional information were received. They based this whole case on this little stuff. That's his opinion, and he said he illegally. I have reviewed encounters available to me in the MUSC Epic computer system between them dates. And it says, Epic provides me access to medical visits. Medical visits. That's a HIPAA violation. You ain't have no right to do that. So let's keep going. Okay, and then it says, the plaintiff conducted the preliminary investigation required by South Carolina Section Code 63-7-750. Now, I'm going to make you laugh right there. They said that's the preliminary investigation section code law. I told you I've been reading this stuff so long. They gave me too much time. You should have gave my baby back. 63-7 says risk assessment before placement. That's 63-7-650. Preliminary investing section code is 63-7-640. So you got your code wrong, but you didn't conduct it. It says the department should conduct within 24 hours after the child was taken into emergency protective custody by law enforcement or pursuant to ex parte order, a preliminary investigation to determine whether grounds for assuming legal custody of the child exist and whether reasonable means exist for avoiding removal of the child from the home of the parent or guardian, or for placement of the child with the relative. Didn't even try to place her with a relative, honey. Just took her from school, if they had taken my baby, asked to take her where they investigate, and place her with my aunt where she wanted to be placed with, that'd have been fine. Now let me tell you about that. It's in the case dictation notes. My baby told the guardian ad litem, Jackie and Jerry Land, read it, that she would rather stay with the foster mom, Miss Kayla. She said Miss Kayla was nice to her versus going with her father. She asked to stay with my aunt first, but they said no, can't stay with her. Now, why would they not let her stay with her aunt? I'm tell you why. Because my aunt knew that what they did was wrong. They had no right to come into our life and just take my child without doing an investigation, without placing her with a family member. So they wouldn't let her stay with her. But you let her stay with the convicted felon in Georgia. After my baby begged and did not want to go to Georgia, they made her go. Now she's being abused, physically abused, mentally abused, and neglected at the hands of these judges. Okay, it means for minimizing the emotional impact on the child of separation from the child's home and family. See, that's what they're supposed to do. You didn't do that because you took her from us and you just stole her life away from her. During this time, the department, if possible, shall convene a meeting with the child's parents or guardian, extended family, or other relevant persons to discuss family problems that led to the intervention and possible corrective actions, including placement of the child. These people ain't talked to me about nothing. I told you that I only talked to that lady one time on November the 3rd. My baby told her she was safe. If my baby life, health, and safety was in imminent danger, she should have filed an ex parte the next day or that day. She did. She waited till December 13th because she knew she didn't do an investigation and didn't think I was going to catch her. Okay? So, once again, and I'm going to tell you, you know they didn't do a preliminary investigation. It should conduct it within 24 hours after the child was taken. They took her on December the 14th. So that means the 24 hours will be by December the 14th the next day. Remember I told you I had to go to court in front of Judge Connors? Remember I told you I had to go in front of her? I had to go in front of Judge Connors. Let me find a little document real quick. in front of Judge County. Here, go right here. So you know they didn't do that. I ain't had no meeting or nothing with them people. Them people didn't care about having no meeting with me. They just wanted to do what they wanted to do. I was in this courtroom 24 hours. They ain't had no preliminary investigation. Cause ain't nothing changed from the 14th through the 15th. Okay, so we're going to keep rolling. Keep showing. These are laws. Then it says, oh, Lord Jesus. The plaintiff conducted preliminary investigation required by South Carolina. Section Code 63-650-7-740. Plaintiff was unable to place children with a suitable relative or non-relative. Now you said you was unable to. Up here you said you didn't do it because I refused to name a potential caregiver. So I refused down here. Then down here you came and said plaintiff was unable to place children. Why? You knew where I lived at. You should have placed her during your investigation. This document is dated December the 14th. So you had already taken her. So what are you talking about? You was unable to place said children or child with a suitable relative or non-relative. You could have done that from November the 3rd all the way through December the 12th. Because you know the baby wasn't being harmed or hurt. So when you look at that, then I'm going to show you another lie they told. Lord have mercy, it's just getting worse and worse and worse. Now they say they couldn't. Then they say I refused. Then you come here and say you didn't have no knowledge of the family prior to the removal of the minor child. And you come down here and say DSS was unable. No. DSS had no knowledge of this family prior to the removal of the minor child. So if you didn't have no knowledge of me before you took her, how you get to her school? How does Haley call me and ask me to meet her? How y'all send me mail to my house? So Dr. John Melville didn't have my address. So when you call her doctors like you should have and you didn't know my address? Because I signed a medical release form and a school release form on November the 3rd. Now you said, Lord have mercy. Okay, let's keep going. Well, I done caught these people so many lies. This is a falsification of documents. Okay. Oh, Lord, then it says that as a result of the hurt or harm, herein the children's physical and or mental condition was and or is as follows. Due to the nature of the abuse, neglect, the minor children, well-being was in danger. South Carolina Department of Social Services in Greenville County has made reasonable efforts and has worked and offered to the defendant services to prevent removal of the children from the custody of the defendants. Lord have mercy. Then they come back with this little or was unable to provide services to these defendants prior to the removal. Why was you unable? Because you met me. We talked on December the 3rd. You got the case on October 27th. So I don't understand why you weren't able to. You had all that time from November the 3rd to December, we're going to say the 12th, to do that, to offer me services. You send me something certified? You email me something? You ain't offer me no services because you said in your reasonable efforts you didn't know me. We're going to keep going back to this. DSS had no knowledge of me. Then you said you didn't offer me services. You sure didn't. Was unable. Why was you unable to provide services to prevent the necessity of the removal? Why? I would like to know why. Because you didn't want to. And you know you didn't do an investigation. So let's keep rolling. And then it says, as stated in the attached affidavit. And y'all ain't say nothing, honey, about what y'all did. Trying to play games and be deceptive right there. It says, now regular supervised visitation with relatives. I hadn't seen my baby for like 2 weeks after they took her. I think it was about 2 weeks. She was crying every day. This lady let me talk to her though. And then a little foster care lady, my baby really liked her. That lady, when we was on the meeting, she said, I really would want her to talk to her mom because she cries every day to speak to her mother. She sure did. Because she loves me and I love her. She know I wouldn't hurt her. She cried every day. That lady said, I want her to talk to her mom. And they had agreed to do it, but she left. They shipped her to Georgia like a day or so later. I had supervised, I got to see my baby once at Starbucks, about 2 or 3 times at Starbucks before she left here. I feel like a criminal when I'm a loving mother. These people need to pay for this. That the defendant should be required to provide regional support through the clerk of the court. Oh, I forgot this one. that the above named defendants are not in agreement with the placement of the child in an alternative study, which means not in agreement. You kidnapped her. How was I gonna be not in agreement? Remember, you just went to the school and took her. Remember that? Cause you remember that? Cause you forget that? Cause you said you didn't have no knowledge of me before you took her. You just took her from school. DSS did not have prior knowledge of this family prior to removal of the minor child. Then it says DSS was unable to provide services to prevent the necessity of the removal of the child. Then you come back and say, I was not in agreement with the placement of the children in an alternative setting. Whoo, child, these people here. I'm almost finished. Then it says, now I'm tell you, when they finally took her, I supposed to have visitation two weekends after month. You know, her dad didn't bring her to visitation for 8 months. Do you not know the emotional impact that had on that child? And she down there in the house by herself. And that man was working 17, 18 hours a day. My baby is not used to being by herself. She don't like being by herself because it was just me and her. So she didn't have to be by herself. No counseling. Did see if South Carolina had it done right and went through Georgia, Georgia would have got her a counselor. They would have had a caseworker going out to their house checking her father. He would have got locked up in Georgia for that because he already got 2 felony convictions. Well, Georgia would have said, no, you can't put her here. South Carolina, they just broke a law, a federal law. They're supposed to have approval from Georgia to put my baby in that state. Law-breaking judges. Okay, then it's talking about child support. I had went through years trying to get him on child support. I finally got him on during the pandemic. So they gave me a little something. In January 2022, because they took her December of 2021, I was supposed to start getting a nice sum of payments to help me take care of this baby. Judge Catherine Tiffany stopped it. All that time, it took me to get it. And he wasn't helping take care of that baby. And then y'all take it away to help take care of that child. That's why he don't want to give her back. Because everybody keeps saying, why he just won't give her back if he can't take care of her? Because he don't want to pay child support. And they ought to have enough sense to know that. The Central Registry, they said they weren't going to put my name in there, is what they said. Sam Weldon signed this. Now look, let me show you this last little ISO. Placement plan. File. Let me show you this because the camera going to probably cut off in a minute. This is upon a favorable home evaluation, approval of GL, physical custody of the minor children can be placed with a relative or suitable adult without further order of the court. Favorable home evaluation. Now, I tried to set this up with this lady. I'm going to show you how she lashes that she didn't know me. Now, look. Services provided by the Department of Social Services. Services offered. That under the circumstances and based on the nature of the allegations. Look at this. DSS does have prior knowledge of this family prior to the removal of the minor child. Now they're saying they do. Really? Ain't that crazy? Now they don't know what they're doing. Oh, Lord, why service is not successful in preventing custody? Service would not have prevented the EPC from taking place. Why not? I mean, what does services have to do with that? You give me services. I'm just saying, what kind of services can you give a mother anyway who takes a sick child to the doctor and nobody can figure out why the mom and the child's sick and her physician's giving her referrals? I'm just understanding, what kind of services would you give to me? What would you say? Don't take her and let her bleed and hemorrhage to death and die? This is not making any sense. Then it says a meeting. A meeting was convened as provided by 63-7-640 with the following persons present. No meeting took place. You right. They say it was conveyed. Then they come back around and say it wasn't. Efforts to place with relatives. Department of Social Services could not complete home studies on suitable adults or relatives. Now remember, this came up here. Could not do it. Because you said I refused. Remember that? You said Clarissa not complying with DSS and refusing to name a potential caregiver. You said I refused to. Then you came back down here. Remember this? And Miss Haley, you said the mother does not have any family or friends that the child can stay with. I was born here. So was my parents. I have siblings here. The mother has refused to sign any releases of information. Now, you know if she lied on that, she lied on that because I signed a medical release and a school release. And then she come back down here. This is the last one. That's pretty much it. Look who that signed by, the little liar. I just dissected this document. This ain't nothing but full of lies. This is a falsification of document. These people set me up and framed me. And guess what? Those judges had to look through this. They would have been able to stop these people in their tracks, but they don't. Appeals Court, Supreme Court, y'all got to help us out in Greenville County. You got to help us out, please. Help these women out. They losing their children because of this kind of stuff. This is how I lost mine. Y'all need to give me my baby back. Because I'm holding somebody go, this is not over. This is not over. So please keep following, sharing my videos. You know somebody on a news station, radio, share it with them. Because these people set me up and frame me. My YouTube channel is Clarissa Speaks the Truth, because that's what I do. Good night.